Most landlords who lose an eviction case in Alameda County didn't lose because they lacked a valid reason. They lost because the notice was wrong. Maybe the wrong form. Maybe a missing mailing step. Maybe the date on the document didn't match the day it was actually served. The judge doesn't fix those errors. The case gets dismissed, and you start the whole process over. Today, I'm going to walk you through exactly how to serve a California eviction notice so that doesn't happen to you. There are three main notice types, and which one you use is determined by why you're ending the tenancy, not how long the tenant has been there. If the tenant hasn't paid rent, you serve a 3-day notice to pay or quit. This gives them 3 business days to pay in full or vacate. The notice must state the exact amount owed, not an estimate, not a rounded number. Exact. If the tenant is violating the lease, an unauthorized pet, an unauthorized roommate, you serve a 3-day notice to cure or quit. 3 business days to fix the problem or leave. The notice must describe the specific violation. Vague language like "you're in violation of your lease" is not enough. And if the conduct can't be fixed, criminal activity, serious nuisance, you serve a 3-day notice to quit with no cure option. No second chance. Document the conduct thoroughly before you serve this one. One wrong choice here, and the case is dismissed before it's even heard. California law gives you 3 ways to serve a notice, and they must be tried in order. First, personal service. Hand it directly to the tenant. If they refuse to take it, leaving it in their presence is enough. The notice period starts the same day. If the tenant isn't home, you can give the notice to an adult household member. But, and this is where most landlords make a mistake, you also have to mail a copy to the tenant on the same day. Both steps, same day. If you skip the mailing, the service is defective. If no one's home after reasonable attempts, you can tape the notice to the front door and mail a copy the same day. But here's the critical part, and this trips up a lot of experienced landlords. Post and mail service adds 5 calendar days to the notice period. Your 3-day notice is now effectively an 8-day notice. File your unlawful detainer before those 8 days are up, even by 1 day, and the case is automatically dismissed. Here's the 3rd most common cause of dismissal, and it's completely avoidable. The date on the notice must match the date you actually served it, not the day you wrote it, not the day you printed it, the day you served it. We see this all the time with self-managing landlords. They prepare the notice at their desk on a Tuesday, track the tenant down on Thursday, hand it over, and the notice is dated Tuesday, dismissed. The fix is simple. Leave the date blank when you prepare the notice. Fill it in by hand the moment you serve it. At all East Bay properties, we treat notice preparation as a legal document review, not paperwork. Every notice is checked against current California law and the applicable local ordinance. Oakland and Berkeley both have additional requirements on top of state law before anything goes out the door. If you've got a tenant situation right now and you're not sure which notice applies, or you want to make sure your service method will hold up in Alameda County Superior Court, don't guess. A 10-minute review before you serve is worth more than weeks of restarting. Visit alleastbayproperties.com or click the link below to schedule a free consultation. The full written guide with notice type tables, a pre-service checklist, and Oakland and Berkeley specific requirements is linked in the description. Thanks for watching.